Thank you. Good morning. I'm Jim Sandman. Please call me Jim, or you can just call me Sandman. A lot of people just call me Sandman. I prefer not to be called Mr. Sandman. You know why. I can't order a pizza without having that song sung to me. Whereas just plain Sandman is like the Metallica song, Enter Sandman, much cooler. I'd like to speak this morning about one particular type of practice, unbundled legal services, limited scope representation as a tool to improve access to justice in the United States. My perspective on these issues comes from my position as president of the Legal Services Corporation, which is the country's single largest funder of civil legal aid programs. We fund 134 independent legal aid programs serving every county in every state, the District of Columbia, and the territories. Here in Maryland, we fund the Legal Aid Bureau of Maryland. To qualify for services at an LSC-funded legal aid program, a client, as a general matter, can't make any more than 125% of the federal poverty guideline. That's currently about $30,000 a year for a family of 4 and about $15,000 a year for an individual. We have a crisis in civil legal services in the United States today, and I'd like to give you 3 quantitative indicators of the magnitude of that crisis. The first is the number of people in the United States who meet that income eligibility standard, 125% of the federal poverty guideline. That number is currently 63 million people, 20% of the American population. Here in Maryland, the number is 782,000 people who meet that standard. That number is about at an all-time high. It spiked in the recession. That number is up about 24% from 2007, the last year before the recession began. And although the unemployment rate has now come down to about 5%, the size of the poverty population has not come down. A second measure is what we call the turnaway rate. How many people show up for service at a legal aid program but are turned away because of inadequate resources? The Boston Bar Association last year did a study in the state of Massachusetts that showed that legal aid programs there were turning away 64% of the people who showed up for service. The Legal Services Corporation did 2 studies, one in 2005, one in 2009, that showed at the legal aid programs we fund, half of all of the people who requested service were turned away with nothing. Now, keep in mind that that measure, the number of people who are turned away, vastly understates the unmet need. That captures only people who knew to go to a legal aid office, who self-identified their problem as a legal problem and knew where to go for help. It doesn't capture the people who didn't think of their problem as a legal problem, didn't know where to go, or didn't bother going even if they knew where, because the word on the street was, it's a waste of time. You'll be turned away. Other measures look at percentage of legal needs that go unmet among low-income people every year. Studies repeatedly have shown that number to be around 20%. The Maryland Access to Justice Commission reported in 2013 that that number in this state was 22%. And a final measure of the magnitude of the problem is the number of people who are appearing in courts across the United States every day alone, without a lawyer. There are not good national numbers on that phenomenon, but where they exist at the state level, they're astonishing. In California, 4 million people appear in the state courts every year without counsel. In New York State, it's 1.8 million appearing in the state courts without counsel. The phenomenon is particularly acute in 2 categories of cases, housing cases, particularly evictions, and family law cases. I did see a number from Maryland in 2013 that said in civil cases of any kind in Maryland, 70% of civil cases in Maryland, at least one party is unrepresented. And I'm confident that those numbers are through the roof when you're talking about family law cases. Well, as the book points out, we have a legal system that was largely designed by lawyers for lawyers, built at every turn on the assumption that you have a lawyer. Everything from our rules of procedure to our rules of evidence were written for lawyers, and they don't work for people who don't understand them. So one of the things that we're trying to do in the world of legal aid with very limited resources is to rethink the service delivery model. It is simply not possible to provide full scope representation to everybody who needs it. That might be the ideal. It is simply not achievable. But we need to move away from a system, a status quo, where so many people are turned away with nothing. What we have to do is design a continuum of services that provides some form of effective assistance to everybody. Some form of effective assistance. All of those words are important. Effective to 100%. Sometimes that might be a court-based self-help center. Sometimes it might be online resources. Sometimes it's going to be full scope, soup to nuts representation. And sometimes it's going to be unbundled legal services. I hear sometimes an objection to unbundled legal services as a solution to trying to address the crisis in civil legal aid. The concern is that it's going to relegate people who can't afford full service to second-class justice. To me, the question is always compared to what? And to the populations served by the legal aid programs we fund, the choice is not between full representation and limited scope representation. The choice might be between limited scope representation and nothing. And I am confident that competent limited scope representation is way better than nothing. In fact, it can allow you to target the service to the area of most need, whether it's taking depositions or appearing in court, which is immensely intimidating to people. They don't know where to sit, they don't know when to stand, they don't understand the language of the courtroom. If a lawyer could just take care of the court appearances, particularly in contested proceedings, that could go a long way toward reducing the intimidation and making the process much more effective for people. Now, my understanding is that you recently adopted extensive unbundled rules here in Maryland. We've done something similar in the District of Columbia where I live. I would offer this recommendation based on what I've observed of the process in the District of Columbia. Rules are necessary but not sufficient to cause people to avail themselves of unbundled legal services. Lawyers are afraid to do it often because you know what their concern is? The judge won't let me out. I don't care, even if the rules say that I can only be in for a limited purpose, I won't be able to get out. That's why there needs to be education both of lawyers and how to do this and of judges about the way the process needs to work. When it's implemented, I think it can expand access to justice among one population of lawyers in particular in the family law context, pro bono lawyers. It can be very difficult to recruit lawyers in private practice, pro bono lawyers, on a volunteer basis to take on a family law case if they think they're going to be in it forever. And particularly if there are children involved, they're concerned that the representation might go on for years and years. Unbundled legal services is a way to recruit those and where they can limit what they know they're taking on at the outset of the representation. It can also expand access to justice for an additional population beyond the one I've been talking about, very low-income people. It can help with people of modest means who don't qualify for civil legal aid, who have some money but not enough to be able to pay for full representation. And for them, the opportunity to call a lawyer in to help with the most intimidating aspects of the case can make the difference between their perception that they have access to justice and their perception that the system has failed them. Thank you very much.